Just a quick disclaimer, I'm much more comfortable in the courtroom than I am in this room, okay? Something about a jury of your peers, is not what I'm accustomed to. Anybody know what anniversary this year is, 2018? What happened 100 years ago? Any idea? Any guess? The Workmen's Compensation Act, the first workers' comp legislation in the history of the world, 1918. So this is a 100-year anniversary for us. Just a little thing I thought of, kind of relevant here. Prior to that, all work injuries had to be litigated based on negligence on the part of the employer. If an injured worker could not prove the employer was negligent, the liability was considered their problem, literally. Okay. In short, employers had no obligation to an injured worker. The thought was if you entered a dangerous occupation, you're responsible when you get hurt, or you shouldn't have been doing this kind of work. That wasn't a real effective way to handle the problems of injured people, particularly railroad workers and a lot of other, heavy offloaders and people doing dangerous work where there were lots of injuries back then. And so the work comp idea emerged in around 1913 through 1918. That you should recall, has led to all of the work comp systems in the country that each state follows now. It's considered the grand bargain. Give up negligence and the burden of proof in exchange for easy access to benefits, services, and partial compensation, wage replacement. All right, how many of you have seen an independent vocational evaluation? Had one cross your desk? Is there anybody who hasn't ever seen or read or heard of an IVE? Okay. How many of you have performed an IVE at least once? Okay. Pretty good number. There's about 300 QRCs registered in the state, and just kind of, thinking myself, I could identify at least 30 people that I know who on occasion perform that kind of work activity. My guess is it's probably much more. So, let's start with the idea that somewhere around 10% of the QRCs registered may do an IVE. And the rest of you, at some time or another, you're going to come across one. You might be a victim of one, or you might be supported and your work enhanced by one. Depends on, the dynamic. Okay? I think there's a lot of people that could give this presentation, very likely many of them better than I can. But I just want to recognize that the way I was taught and the way I developed my technique as an expert is unique to me. It's based on reasonable foundation, but there are many other ways to do this, and I don't consider anything that I'm going to tell you to be absolute gospel. If you have a better way or a way you like to do it, do that. If it works for you, continue to do that. If it doesn't work for you, change it, okay? I have no idea how many evaluations I've done. I'm sure it's in the several hundred. Most of them are work comp, but I've also done a lot of PI work, long-term disability, a few Social Security disability. I've done divorce cases. I've done a number of discrimination cases. It doesn't seem that common, but they are out there. And then a variety of different federal jurisdiction cases. The federal cases are a different kind of a deal from what we see in Minnesota work comp, okay? Just keep that in mind. I'll try to talk about that a little bit toward the end if there's time. Okay, when I talk about independent vocational evaluation, I'll use the term expert, vocational expert, and other things. I'm talking about the same thing, okay? My opinion, expert work is not for the thin-skinned. Okay? If you don't like getting your feelings hurt, then don't put yourself out there to do that, because it will happen. Anytime you offer an opinion in a court case deliberately for that court case, not as part of your casework, but for the court, the other side basically has no rules in what they can do to embarrass you, to make you feel bad, to put you off your game, off your mark, to get you confused, frustrated, angry, or anything else that they can take advantage of. They'll put guys like this character up at the front table here to make weird faces and distract you during the middle of your testimony. Okay, anything is fair game in court. Okay, as I see it, expert work is a teaching activity. What you're there for is to tell and teach the judge, and in some situations the jury, what they need to know to make a valid decision about whatever damages or vocational losses or needs are involved in that legal action. So you're telling them what vocational rehab is, what vocational evaluation is, how services are or should be provided, and then how you reach your opinions and conclusions in your evaluation. A lot of venues, motor vehicle, as well as a lot of federal cases, other personal injuries. Earning capacity is a huge issue. Loss of earning capacity is a huge issue. You have to quantify it. You need numbers. You can't just kind of ballpark it and expect to be successful and working in that capacity very often. It's more perspiration than inspiration. The smart people may have an advantage, but the hardworking people tend to prevail in that environment. There's no fast, easy, convenient way to get through it, and I believe fully that I can outwork the experts that are better trained, better educated, smarter, and more talented than I am, okay? And I think I've had a good measure of success doing that in the past. So more perspiration than inspiration. Not any really good shortcuts or easy ways to do this kind of work. In some venues, expert work is war, okay? No holds barred. Winner takes the spoils. They take no prisoners. They offer no quarter. Okay? It's not nice. It's not supposed to be nice. Somebody's life may be on the line. Their financial life, their future life, their medical needs, and somebody's money is on the line. Whoever's being sued, may have to pay substantial awards in some of these cases. Now, I just came back from a seminar last week, and there were people talking about $74 million cases. There was an MD who was doing a patent infringement case on a pharmaceutical action that they talked about it being a $1 billion case. Okay? Now, that MD is not in my category. Those guys were charging $1,500 an hour every time they, kind of vaguely thought about the case. And they had, according to what they were describing, they had kind of an unlimited budget. And you can imagine with $1 billion on the line, they don't care what the expert work costs. So it's war. One of the rules, of course, is never bring a knife to a gunfight, all right? If you don't prepare, you don't work, you don't do your research, you don't make the effort to do it and do it well, you're going to get outgunned, plain and simple. Now, in my mind, if you hate attorneys, expert work probably is not for you. You have to talk to attorneys, you have to spend time with them, you have to listen to them, You ever met an attorney who doesn't like to hear themselves talk? Let me know. Okay? If you love attorneys, always wanted to be one, I dreamed of going to law school, probably not for you. Okay? They will disappoint you, they will abuse you, they will lie to you, they will misrepresent the facts of the case, and then expect you to distort your opinion to fit what they want and need. They think of it as, I'm paying for it, you give me what I need. I think we all know that just doesn't work, but attorneys doesn't stop them from going there time after time. You want to remember, attorneys are sharks, plain and simple. They went to school for 3 or 4 years to learn to become a shark, to learn to lie and misrepresent professionally, how to beat witnesses up, how to get people to say things they don't want to say or didn't intend to say. So keep that in mind. They are sharks. What does that make us? Shark bait. Correct. We're guppies in their world and in their mind. We're these little fish that they just, chomp on at their leisure. And again, they see it as war. They're there to win. They don't have to be nice. They don't get paid to be nice. They don't make more money for themselves or their client, whomever that is, by being nice. Okay? You can also think of the courtroom as theater. Everybody has a part. You play your part. The attorney's part is to be a shark. Your part is to survive the shark attack, okay? And still teach the judge and jury what you would like them to understand and learn so that your opinion is adopted in the judge's or jury's final determination. As I see it, it's hard to do expert work on a hit and miss basis, okay? If you only rarely do it, you may do a great job, but in my experience, and when you go out and talk to the national experts, the real big guns, they all emphasize it takes practice, it takes repetition, it takes a dedication, determination to do it well. And I think that's somewhat true in the Minnesota work comp system. We have a much softer system. The rules are kind of less rigorous. It's still somewhat a good old boy system almost. Good old boy or good old girl system. You know that from your casework anytime you go to court. You don't really get beat up by making a small mistake. In other venues, you make a little mistake, they drive a huge hole through it. Okay? It can get you disqualified from a case, get your testimony, your opinion thrown out so that the judge and jury never hear it. Okay? So again, it's big stakes. You can do it on a part-time basis, but if you want to be effective and successful, it takes a little more investment and dedication to it. You need to be able to support your opinion in a forensic environment. Everybody has an opinion. I have a 7-year-old granddaughter. She has an opinion on everything. She doesn't know much, not yet. And you think of it that way. It's not having the opinion that's important. It's being able to support it, being able to show a rationale. And again, in our system, the rationale is based on the rules, understanding of the statute, and some clinical experience. In the federal court system, supporting your rationale is everything. Okay? If you can't articulate what theoretical perspective, what methodology, what scientific evidence you bring to the activity, you can be, they call it, dauberted out of the process. And so you have an attorney that's maybe spent, $4,000, $5,000, $6,000 paying you to work up this work. And if you're found to have made a methodological error, that money goes out the window, the attorney gets nothing back, and the case moves on without you, okay? All right. Vocational assessment, I just want to differentiate. Lynn Vincent's a vocational evaluator, the real deal, okay? Anybody remember Elroy Kelly? Yeah, great guy. He was a real vocational evaluator. There used to be a guy at St. Paul Rehab back in the day. Anybody remember St. Paul Rehab? It was a dedicated rehabilitation center. They had Valpar equipment. I can't remember his name. I can see his face. He was a real vocational evaluator. We have a few, in the audience here, or among the QRC ranks anyway. Vocational assessment, as I see it, is what we all do when we gather data, we gather testing information, we do a transferable skills analysis, or at least we kind of do one, for the purpose of developing a plan and delivering services. You have to develop some job goals. You look to the client and you say, what do you want to do? Well, they don't know. So you have to start somewhere, and so it's a brainstorming activity. Vocational assessment becomes more formal when you want it and need it to, but that is different than what I'm talking about in this kind of independent vocational evaluation. So John read a definition of voc-eval, I think, for the intro. It's a comprehensive evaluation, comprehensive analysis. Everything is included, everything is considered, and the emphasis is on analyzing and evaluating to support your opinion. This kind of work is specific to the venue that you're in. You all know that SSDI rules and their criteria are different than work comp, different than motor vehicle. They even have different acronyms in the field. And then federal and other kinds of personal injuries, other kind of actions, they all have different rules, different goals, and different ways that they work. So this kind of forensic work is specific to the venue, and it's done with the clear knowledge that the results will lead to specific legal consequences to the party. Somebody wins, somebody loses. There may be a split decision on occasion, but still, you lose or win that part of the decision. Like Ray Peterson talked about a couple of years ago, experts, QRCs, service providers, we don't win or lose, literally. The attorneys do. But when you're paid to be their professional, their expert, you want to be a big part of that winning or losing strategy and outcome. Otherwise, they're not going to use you in the future. If you're not effective, if your testimony isn't meaningful, if it's not pertinent, well, why would they hire you again? Okay. All right. Now, just a hypothetical. Should an IV report be short and specific to the point, or should it be long and comprehensive? Anybody have an opinion? Depends. Yeah, depends on who you are, what you like, how you work, and depends on the venue that you're in and who's hiring you, who's employing you. Okay, if an attorney retains you, they are literally employing you. Okay, you still have impartiality, neutrality, if you want to call it, but you are literally working for that part of the court system. You're not there to represent the Department of Labor and Industry. You're not there to represent employers or other factions. You're either on the defense or the petitioner side. I prefer long, detailed, thorough reports. It's just the way I work. I'm OCD. I just cannot break that habit. I know there are other people. I'll illustrate with Jan Lowe. Jan Lowe kind of writes a general summary report, cuts to the quick, gets right to her statement, gets out of there, gets it done, sends it out. She puts, I think, more time into the labor market research, generating stats and that kind of thing than she does into her opinion. Now, I believe she has a strategy for that, and I understand that strategy. It works very well for her, allows her to come into court and talk about things that the other side may not have had time to digest and evaluate and prepare a response to. That works well in Minnesota work comp. I don't know if it works as well in motor vehicle cases and other venues. It, in my understanding, would not likely work well in a federal jurisdiction case. Okay? In the federal system, you can only testify in court on the issues and the opinions and the data that you used in your report. If it's not in your report, there often is a discovery deposition involved in the federal process. If it's not in your report and it did not come out in the deposition, you are not allowed to say it in front of the jury. Okay? If you do, you risk having that stricken. It's a big kerfuffle, and can be bad for the case, bad for you. All right. Just for definition, transferable skills analysis. And by the way, this is kind of a pet project of mine. TSA I'm defining as an acquired or is a skill acquired as a result of work activity and available for transfer to a different job requiring similar or lower skill level. You don't have a transferable skill if your past experience has a skill component at this level and the new job requires a skill at this level. That's not transferability. That may be an advantage, it may be a strong, trait or characteristic, but does not fit the definition, okay? Things that are academic skills, not transferable skills, not unless you learn to read on the job, okay? Is reading a transferable skill? Maybe, if you're a proofreader, if you're an editor, publisher, if you read copious amounts of material as a part of your job and develop that skill as a research librarian or a legal researcher, maybe. For the rest of us, reading is an academic skill, personal skill, basic skill, not subject to transferability to a new job. Okay? You can potentially persuade an employer that it might be, but it's not. Okay? There's a lot of other examples of, is driving a transferable skill? Well, if you're a professional driver, yeah. But if you're, my 16-year-old daughter, no. She got a license, she drove the heck out of the vehicle she had. It was not a transferable skill, or God forbid, does she ever wind up in a driving occupation. I'm picking her. She deserves it, though. Trust me. Okay. I see a lot of transferable skills lists in reports that I'm evaluating, your reports, that give me a lot of concern. I can't do justice to what I'm referring to, but I've seen people refer to a high level of motivation as a transferable skill. Okay? I don't really think that fits the definition, anybody's real definition. Now, I understand why people do that. We all do that. When we're working the case, we're trying to generate ideas. We're trying to do counseling and services. We're not preparing it for a judge to make a technical determination of this person's employability. So in your casework, you generate lots of ideas so that you have something to look at, something to start with, something to work on. That's great. What's important to me is to know the difference, though. To know that when you generate lists of ideas, even if you call them a transferable skill, put that in a report, tell the insurer, yeah, we have something to work with. That's great, but you need to know that when you report to the courtroom, you should not define it and describe it the same way. Okay? It's wrong. It's professionally wrong. It's ethically wrong. Probably morally wrong. Okay? Again, there are consequences to what we do particularly in that environment. Okay, we have primarily, I had a question here for you. How important is it to distinguish between a TSA and a worker trait? Okay, very important. It's important, again, to know the difference and to be able to articulate that difference when it's appropriate. Okay, I don't care what you tell your clients, and they don't understand any of what we're talking about technically and how we get to these things. But when you're reporting to court, know the difference. We would all be better off if we were more precise in our language and our labels. But we all have the same tendency and habits. Anybody gone to an employer meeting and called it a job site analysis? Anyone? No? Am I the only one? Okay. Well, I've seen it. I've read it in your reports. Okay. Had a case where over and over again in the report it documented, I'm going to do a job analysis. I did a job analysis. And then the description was of about a 5-minute discussion with the employer, looking at some handrails in the nursing home, making sure that this person could wipe down the handrail, do a little bit other light, very light work. Now that's all the QRC intended to do. That's all they wanted to do or needed to do. They called it a job analysis. Okay, I understood clearly what they were talking about, what they were doing, and why. But in court, if you call that a job analysis, people think of the definition of job analysis found in Minnesota Rules 5220, and it didn't approximate that. I think we'd probably do similar things to that all the time. Okay, so we all could likely benefit from more precise language on some of these technical definitions, these things that can confuse people later. Okay. There's basically 2 databases that we have to choose from for occupational analysis to understand a job, the requirements, the expectations, the demands, the skills, the specific vocational preparation, the general educational development required and involved and demonstrated in those jobs. It's basically the DOT and the ONET. Okay. There's all kinds of other variants of those on the market. The one that comes to my mind or came to my mind immediately when I was drafting this was the EDOT. Okay, anybody seen the EDOT? I came across it in an evaluation about a year ago. EDOT is the electronic DOT. Okay, and it's a private group. I don't know where they came from or how they formed, but it's a private group that was attempting to update the Dictionary of Occupational Titles, which, our government can't do that, but this group was going to do it. All right. I found another expert using it as an authoritative source for occupational analysis. When I looked it up, and I wasn't familiar with it, I'm like, what the hell is this? I looked it up, and there's a disclaimer. One of the first pages on the website, small print, but it was there. And the first thing they said is, we make no claim that this data is reliable, valid, or useful in any other way. So of course I rebutted the other expert on the basis of that, and the case quickly resolved just on that single issue. Be aware that the Dictionary of Occupational Titles is the authoritative source for occupational analysis in the Minnesota workers' comp system. Okay, it's right in 5220, somewhere in the beginning. I think it's under definitions, if my memory's right. Okay. Now, I don't know why that is. We all know the DOT is horribly dated, virtually useless in some job descriptions in some ways. But that's why we have the ONET. Okay? We're all entitled to our opinion, but is the ONET any better? Okay? And you should think about that. I'm not sure what it's better at. okay? It's incomplete. To my knowledge, it's never been actually finished as a comprehensive database for our labor market, okay? I'll talk a little bit more about those two later. Okay. You can do an occupational analysis. You can break down a job description, all the requirements, the aspects, the factors involved in it manually. Matter of fact, a good number of us, that's how we started, with the old DOT books like this, jobs classification book, the Occupational Outlook handbook, jobs analysis book, and you just spend hours and days just wading through, just looking for anything that you could, latch onto, and hoping and praying that somebody didn't find a description that was better than the one that you picked. Okay, my first Social Security disability case, and I was brought in by an attorney. It was right when the laptops came out. I had this teeny little laptop, and all I had on it was Oasis, okay? Chuck Roble was the rep back then. Some of you may have known Chuck. Great guy, great character. And I really didn't know how to use it, but I could kind of, I could get a job description, I could enter, some terms, and I could get some job titles through it. And the SSDI expert testified that my client was employable on the basis of a job description that the judge had given in the hypothetical. And then the attorney got to take his turn, and the judge was really critical because the attorney didn't have a clue what he was doing. I didn't have a clue what I was doing. And they were just about to shut the hearing down, and the judge asked me another question. And I said, well, Your Honor, my problem with your expert is she used the wrong job description. Because I had been banging on my little laptop looking at it. Our client was a punch press operator. Well, there's 2 skill levels in punch press operating, okay? Their expert was using the higher skill level that involves setup and some real machining type or operational type skills. My client didn't know anything like that. She just knew to keep her hands away from the punchy part and to hit the 2 control knobs at the same time so she didn't lose her hand, okay? That's literally, she could put the part in, take the part out, hit the control. Once I made that point to the judge, we talked about it a little bit. The judge reframed the hypothetical, asked the SSDI expert, now using that description, he also interviewed the employee or the client, the applicant. And the expert said, well, on the basis of that, no, I would agree she's not employable, okay? So now that we have these systems online, now that we have the computerized versions of all these things, there are a number of variants to pick from. I use Oasis. Oasis is now owned by Skiltran. Skiltran has other analysis software that they market. There's the McCroskey system. And has everybody seen McCroskey? Yeah, you guys use it. You've used it since Billy Joe was in St. Cloud, I think, probably, right? Jan Lowe uses it. People who like it, okay? I don't really understand it, but that's my limitation. And there's a number of others. There's a program called SEER, I think. It's a little different focus, but there are convenient, easy to follow, easy to use computer applications that help you with the occupational analysis, okay? The key to using those is, the old garbage in, garbage out. You still have to spend some time locating the correct descriptions, the correct information, entering that information to get a good printout or a good result, okay? All right, let's talk about the process. First thing you should do you should see after talking to the attorney, agreeing to the evaluation. Now in work comp, I've never asked or been offered a a retainer or a fee, I guess, retainer, agreement. In other venues, it's very common, and the consensus among experts is get the money up front, don't do a stitch of work until you have a signed fee agreement and any retainer you require to begin your time and your activity on the file. And you talk to those guys and they tell stories all day long about getting stiffed, getting lied to, misrepresented, manipulated by attorneys that ask them to do the work and then don't want to pay for a variety of reasons, okay? So records should be the first step in the process. They should send you the records in advance. Ideally, I'd get them a week or two ahead of the interview, the appointment time, so they have time to read them, to begin analyzing, sorting, kind of compiling that information. I am of the mind that we should receive anything and everything that may be relevant, okay? Have you ever gotten one of these referrals where the paralegal or maybe the attorney themselves says, well, what do you want? What do you need? And my answer is, what do you got? Okay? Tell me what you have, and I'll tell you I want all of it that could even potentially affect my analysis, my opinion, and be useful in court. Okay? They don't always like to do that for some odd reason. I don't know what the issue is, but you want everything. I try to touch every page. Okay? And you've seen these files that are like this. I don't know how many pages that is, but it's a lot. I try to touch every page. Now, if it's an EMG graph, I'm not going to do anything but touch it because I don't know what the heck those lines mean anyway. Okay? I'll read the narrative though, and I'll tabulate it. I'll mark it with a Post-it of some sort. I use a ever-changing sticker color system. Sometimes forget what the colors were supposed to mean, but I tab them, I write notes in the margin, and I usually have a separate note sheet, and I'm the things that really stand out and that I think are going to be important, I'll take notes on to help prompt my memory later. You have to watch what you write on the margins, okay? Opposing counsel has a right to review your file. If you write rude comments about their evaluator or about the independent medical examiner or about anybody else, that's subject to being used against you, used to embarrass you, used to make you uncomfortable and affect your testimony later. It's happened a couple of times. I had John Ness. Everybody know John Ness? John Ness and Associates. Serious, intense defense attorney. Got my file during a break quickly. I don't know how it was a thick file. I don't know how he zeroed in on it, but zeroed in on one piece of paper that I did not know was in my file. And it pretty much was like, okay, that's a Japanese referral. Harry Carey, he pretty much gutted me after that break. Okay, it was embarrassing. That was a long time ago, and I'll never forget what that was like. I was also underprepared at that hearing. But they have the right to look at your file. They can look at anything that you used or that you show up with in your hand, in your briefcase in court. Doesn't happen very often in work comp. Happens a lot more in other systems. Okay? In the federal system, anything that you wrote is subject to discovery related to a case. They don't care if it's in the trunk of your car, in your office, at home, in your back pocket. If they think you have it and they can get at it, you have to provide it. If you don't, and you're out of the process. All right, second step is the interview. I tend to find that about 2 to 3 hours is what I require for a thorough diagnostic interview of an injured worker or any of the other people that I'm evaluating. Now, My long-term disability evaluations are shorter. Some of the divorce cases are shorter to the point. But for a bigger case, in most Minnesota work comp cases, I'll spend about 3 hours talking to this person. I look at it as this is my perhaps one opportunity to get all the data, all the information I need from them to understand from their perspective. What did they go through? What happened? Why? What were they doing? What were they thinking? I'm a step ahead of myself, I think. To try to tie that together with the records and the material that I have, what I read from the doctors, the QRC, the other people that are writing and providing information about that person, their case. You can do it shorter. If that works for you, great. I just like to spend time. I like to engage in a little chit chat. I think rapport with that person is real important. People will really, if you spend a little time, show them a little positive regard, they will spill their guts to you differently than if it's just a cold, clinical, let's just get right to it kind of conversation or interview. I'm looking for personal history, marital status. What were you, what were you like growing up? What did your parents do? What area did you grow up in? Were you an Army child where you moved all over the country? Or did you, always live in, North Duluth and you've never lived more than 6 blocks from that house you were born in, okay? I actually have a sister that, has never lived more than about a block and a half from the house that we were born in. So there are people like that. And it says something about them, about their worldview, about their, the way their brain works, the way their behavior works. You want to know educational history, obviously. I always ask, well, okay, you graduated. What are your basic skills like? Can you actually read? I may give them a medical report, maybe their own medical report, and say, can you read this? Do you understand it? Okay? And typically they're like, well, I get the most of it, but the technical jargon, it's like, well, I don't get that either, so that's okay. You want to know, can they do their taxes if they chose to? Hardly anybody seems to choose that anymore, but could you if you needed and wanted to? Could you balance your checkbook? Does anybody balance their checkbook anymore? Okay, I don't have a checkbook anymore, but could you if you needed and wanted to? Do you have that basic elementary kind of math skill? I talked to them about discipline. Were you rebellious and immature like I was in high school? Okay. Then you go into later education. Did they do any technical or community college, any university college work, have any other degrees, any in-house training, any on-the-job type training activity? And as part of that educational, because of the times we're in, I always ask about computer skill. Okay. If I don't put it there, I might forget it later. So at that time, I always go into, tell me about your computer proficiency. Are you like me? It's basically a paperweight, or did you grow up with this technology, or did you invest time and work in learning it later as an adult? I don't know your experience, but my experience is it's probably the number one basic skill in our current labor market that affects the employability factors of anybody that's, 55 and older, okay? I knew you would be trouble, okay? Jeff.
Ken, do you ask about siblings' education or parents' education of your evaluees?
If I think about it, I may ask, if they tell me my dad was an engineer, well then, yeah, I'll ask about that. Oh, university degree. Oh, what about your parent? Your mother, your siblings. I had a federal case where that was a big deal because his whole family was highly educated, and he had been a professional athlete, got a degree, but it was one of those. He was playing football. That's all he wanted to do. And the other side was trying to say, oh, he doesn't have any ability. He barely maintained his eligibility. And part of my analysis eventually was, yeah, but playing football in a program like that is a full-time job in addition to going to school. And you talk to those kind of people. You talk to an NCAA, to a college athlete, and they'll tell you that it's almost year-round. The people who want to succeed, they're training and preparing year-round, whether it's a requirement of their team or not. And they just don't have the time that the rest of us may have had to study that little extra bit, to hang around after class and talk with other students or with the professor, that kind of thing. So, in that case, it was very relevant. And I was recommending a unique retraining program for that person. He had been in what's the last Jurassic movie? He had been in that movie, okay, whatever it is. I don't really follow that. And had tried to make it as an actor, not making enough to live in LA, and he wanted to work behind the camera, which there's much more opportunity than in front. He had seen it and done it, and so I was recommending a BFA program at Chapman University in Orange County. Very expensive, but that information on family history was apparently meaningful to the jury in that case. Okay. Obviously, you go into work history. You know how that is. Sometimes it's kind of a cursory thing. Sometimes you really drill in and you want to know job title, job duties. Really tell me what you were doing. You decide based on the case and your feel for the client how much you need and want in that regard. At a minimum, I try to confirm, that I'm talking about the right job, right employer, that I don't have, I'm not thinking somebody is a punch press operator when they were a CNC machinist, okay? And a lot of times I'll pull up the job description from DOT on Oasis while I'm sitting there with the client, show them what I'm looking at and say, now, does this fit? Is this what you actually did? You can do work history any way you want. I like a chronological. It's just the way my simple brain works. You want to talk about ADLs, activities of daily living. What time you get up? What do you do in the morning? How do you spend your day? Oh, you haven't worked in 3 years. What do you do all day? What are you doing with yourself? Are they sitting there reading? Are they watching soap operas? Or are they constantly chasing their chronic pain, trying to find, a moment of relief, a moment of escape, a moment where they can reset so that they can tolerate the next day, okay? So a lot of that, I think, is useful. Sometimes it's just kind of being thorough and doing the job. But I like to talk about ADLs. And then I start with medical history, first, unrelated to the issue that we're focused on. What other history do you have? History of cancer, diabetes. How's your eyesight? How's your hearing? Are they within normal limits? You want, just because it's part of the protocol, I think, you want height, weight. Are you left-handed, right-handed? Often it's very, very significant, but anything like that external to the matter that I'm dealing with, and then drill into the medical history on the case. I'm not sure a lot of our clients fully understand what happens or what has happened, what services they've received, what their treatment has been. When you ask them and they said, well, I had a back surgery, well, what level? L something, you do hear that, I think. They may know clearly, but there are times where they don't. I talk to them about it, and then I kind of compare what I got from them with what the records say. If the records have told me something different and I've had time to review them in advance, well, then I can come back and say, well, maybe it was the L5 S1 disc that was decompressed, and they'll say, yeah, that sounds right. You want that information to be accurate. Okay? You don't want to misstate it. You don't want to make a mistake or an error because, again, it's important to your analysis. And it's important to your credibility in front of the judge or the jury. Professional witnesses who get things wrong are not looked at favorably by the finders of fact. Okay? And then I'll talk about their rehab history. Did you have a QRC? Who was she? Sometimes they remember, sometimes they don't. Okay? Typically, if it's active, they remember. I can't think of one who didn't know their current QRC, but I know I talked to somebody just recently that could not think of a QRC that they had worked with about a year earlier. I don't think that means anything about the QRC. I think it meant something about the client and their level of participation in their own rehab services. And they had kind of been absentee. We talk about them. What happened? What was that like? What did you think about it? What did the QRC tell you? Okay. I try to ask if it's a permanent total disability case. Oh, you've been in job search for 2 years. What does your QRC tell you about that? Okay. I want to know are you as QRCs telling that person that if they just keep looking for work, they'll find a job, no matter how many years it takes? Okay? Or are you telling them something different? Okay? Are you telling them, well, we need to keep looking because we have no other option. If we don't, there are going to be other consequences, other problems. So let's just work together, keep doing what we're able. I'm sorry to ask you to do this. A lot of times I'm told that the QRC tells the person that I don't think you're going to find a job, but you need to keep looking for work anyway. That doesn't surprise me, doesn't concern me at all. What I would like to see in that situation is a QRC saying that in the record. Okay? It does, on occasion, bother me a little bit, although I think I understand why you may not want to put it out there until the right time. But on occasion, it bothers me when the client says, my QRC, my placement specialists agree, I'm never going to find a job, but tell me to keep looking. And I look through, a mountain of reports, and there's never a comment that even implies that that's what the QRC is documenting, that they're taking a stand, offering an opinion, making a recommendation. Okay. Now, again, I understand why that may not appeal to people. You say that in the wrong way at the wrong time, you get beat up. Okay. Somebody may not like it. Could be the insurer, could be a defense attorney, could be the employee's attorney. Okay? They all have their strategies and their schemes, and we sometimes do get, as service providers, trapped within that. The beauty of it being a vocational evaluator and being a forensic expert is you don't have to play patty cake with that stuff. You're there to offer an opinion, so you can just cut right through the BS and say, no reason to continue this job search. This person will never find a job, if that's your opinion. Or, job search should continue, but the injured worker needs to get serious about their obligation to participate fully, and will never be successful until they flip that switch and actually agree to do that. Okay, this next slide is the VRAM model. It's Vocational and Rehabilitation Assessment Model. And it's a really nice schematic of what we've just talked about, what you're looking for in records and in the interview. Okay, I keep it, I look at it occasionally. I've kind of got this internal schematic that I operate from, but every once in a while it's good to look at this and go, oh yeah, I'm not asking enough about employability versus placeability, or about job retention likelihood. So I use this as a refresher. I think it provides a good place to just kind of look at the overall picture of what you're doing in the process here. Okay. All right, vocational testing. Everybody knows about vocational testing. Skill testing, that's the RAT, reading, spelling, vocab, and computational math typically. General ability is IQ testing. Okay, many variants of that. That stuff's easy to find all over the internet. Interest is an inventory or a survey. I don't see it as an actual evaluative activity. You know, you're not really measuring things with an interest pattern. You're describing and surveying their preferences, their likes and dislikes. By the way, interest in my mind is something that should be changing as a part of the vocational rehabilitation process. Okay? The root of rehab is rehabituation. When you have a disability that prevents you from doing the things that you had done previously, vocationally or avocationally, it is an obligation you have as that person to develop new interests. I just told a client yesterday morning, new intake, that she said, well, what if I'm not interested? And I said, well, you have to become interested. Okay? If I can't motivate you and lead you to some new interests in your life, you have to figure that out. If you don't, you will not be happy with the outcome of the system, the process. And she was concerned, she's a PA actually, she's concerned about winding up in some, dumb or low-level, low-skilled job that bores her to death. And I said, well, we can avoid that, but you've got to work on your interests. All you ever wanted to do was medical pathology, okay? She cuts tissue, puts it on a slide, and, answers questions that the doctors have asked or the surgeons have asked. She does the work, she gives it to the MD pathologist, and the MD, signs off on it. And I said, you can't do that. Her hands are blown up. She's got really bad deformed hands. And you can't do that. So you're going to have to think of other things that you could do or that you could become interested in. I hate to see an adverse opinion when I'm recommending retraining for a client, which I do every opportunity I can. I hate to see an adverse opinion that says, but it doesn't fit their interest. My response is, it will. By the time they're out of school, they will be interested in this topic. Their pattern will change. Truck drivers, many of them, all they ever wanted to do was drive a truck. When it's taken away from them, if they want to work, they have to become interested in other things. Otherwise, they're not going to be satisfied. They're not going to have good vocational experience in the future. Aptitude testing, and I just want to make sure I'm clear. Aptitude is an acquired or natural ability for learning and for proficiency, for performance. Okay? Some people think of aptitude as more permanent and fixed. That's not the training and education I had. I see it as changeable, developable, subject to development, based on experience, avocational or vocational, and training or education. Okay, you can develop better aptitude, and you look at the aptitude materials that are out there. If you test a law school applicant, their aptitudes will, they should be, up there. If you test them again after law school, they should not have the same aptitude pattern. They should have some strengths, some proficiencies or learning abilities that have improved as a result of that education. Okay. All right. Okay, this is a chart comparing the DOT and the ONAT. Basically, the DOT is good for assessment, evaluation, transferable analysis, job matching, and vocational guidance, helping people select among the merits of different jobs. The DOT is quantitative. There's actual measurement. I don't know how reliable it is after, 30 30 some odd years of not being maintained and updated, but that's a political problem. Okay, it's not a problem of the DOT. That's a problem of our society that refuses to invest in the infrastructure that we need to do our job. Okay, DOT has had its strong suit. It's still there. It's still used by SSDI. It's still used in the long-term disability field and other venues. Okay, and what are you going to do? Well, you can use the ONAT. The ONAT is good for exploration. It's good for, it's very descriptive, okay? If you want people to explore jobs, explore ideas for future work, show them the ONAT stuff. Go through that with them, okay? That'll help. It'll help generate ideas. But it's not quantitative. There's no measurement. So it's of limited value in an analysis or an evaluative context, like forensic work. Okay? This is by an author, a pair of authors named Weed and Field. It's just me. I just think that. Could you imagine studying under Dr. Weed? Okay, I just think that's hilarious. Well-regarded authors. Tim Field is out of University of Georgia. He has published mountains of material on vocational evaluation, expert work, life care planning, and he's an academic guy, okay? All right, labor market research. And I say research because in my mind, surveys are no longer useful. Picking up a phone and expecting to call prospective employers and get information just is a dysfunctional activity in my experience at this time. Wasn't that way in the 80s. Back in the 80s, the first LMS I did, I picked up the phone, I called about 20 trucking companies. There were guys that would talk to me for half an hour about trucking, about drivers, about mileage rates, about what they look for, okay? You might find somebody that'll do that now, but good luck, okay? And my guess is it would take, to do a good LMS, it would take an inordinate amount of time. And I can't imagine why anybody would want to pay for that time, okay? And it's simply a change in technology and change in our system. Back then, in the 80s, there was no computerized source for that information. I do recall going to the St. Paul Library, trying to find BLS statistics in the St. Paul Library back in the 80s. It was not really reinforced by my supervisor at the time as an appropriate billable activity or work strategy. Today, that's reversed. That information is available in a matter of seconds. It's reliable, it's valid, at least as it's constructed. And I cannot think of a reason not to use the research, and the data, and the information available through sources like CareerWise, that's the old iSeek program, Bureau of Labor Statistics, Occupational Employment Survey, and then BLS has a ton of other data that they have developed on vacancy rates, and so does CareerWise, or the Minnesota Economic Analysis System. So use those sources, and then there's other internet information, Indeed, salary surveys, the kind of thing that you can easily find just using search terms. Here's what I'm looking for. Pay a little attention to make sure that it's a reasonable source, that you're not using garbage, junk in, junk out, that there's some scientific merit in it. I did quote a forum once on truck driving where it was just truck drivers writing and stating their opinions. It kind of slid by, but I had my fingers crossed the whole time. Not a good source. It still, it helped and it helped me. But so look at those sources in terms of, does this really make sense? Does it line up with the other information that we can get and use from other sources? Okay. My opinion, LMS surveys are unreliable and therefore invalid. Okay. I wish it wasn't true. All right, the report, pretty simple. You lay that all out in some fashion that you think is readable, that the other people can comprehend. Review the history, the information, the data that you're relying on. Do your analysis. State your opinion. Period. Okay. What level do you write your report at? Okay. Now, hopefully, you have college level writing skills. USA Today is written at a 6th grade reading level. Wall Street Journal is 8th grade. I'm going to check my fingers. 8th grade. Technical manuals are maybe 12th grade and up. A lot of the legal stuff, 12th grade. Adapt to your audience based on the kind of case it is. Okay. All right. I like long and detailed. Again, others seem to do very well with kind of just a short glossary of the information that they have. Okay, real quick, Mike's given me the 4-minute sign, I think. Federal Rule 702 basically is an attempt in federal cases to make testimony based on sufficient facts and data, okay, as opposed to just my opinion. The witness is supposed to have applied principles and methods reliable to the facts of the case. Okay. 3 important cases in the federal system. Daubert is intended to make that information, that testimony, reliable and relevant. Joyner gives the judge the role as the gatekeeper. The judge determines what gets heard by the jury or not. And Kumho-Tyre recognized clinical experience as technical and specialized knowledge. We're in the social sciences, not in the physical sciences. We're not engineers. We don't have that level of scientific precision. So your clinical opinion, your clinical experience is helpful and useful and allowed in the federal system. Okay, what makes an effective expert? Credibility, period. Okay? You look at this, by much stronger impact than other characteristics. What is credibility? According to Aristotle, it's ethos, which is character, pathos, experience, empathy, and sympathy. Pathos is also that feeling that you get, that emotion you get from listening to music, the things that it makes you feel. And you can do that as a speaker in an audience if you have the talent and the ability. And then logos, logic, order, knowledge. Inductive reasoning, deductive reasoning, and syllogism. Okay? Aristotle wrote volumes about that. Now, in the social sciences, James McCroskey is a speech communication theorist, and he talks about credibility as competence, character, sociability, composure, and extroversion. Okay? You need to be willing to talk to people to have that. It's not charisma, and it's not leadership. Okay? Now, how do you become an expert? Anders Ericsson is a Norwegian dude at Florida State University, has written on this extensively. And his initial theory was practice. Okay? One of his students, Malcolm Gladwell, wrote a book called The Outliers, I think, and he developed what he called the 10,000 hour rule. If you want to be an expert violinist, you need to practice for 10,000 hours. Ericsson came back and said, no. Hours are not enough. It takes deliberate practice. What the violin student does is they have an instructor, and that instructor says, no, you're not getting that. And you work on that until you do. So it's deliberate practice. Working on your weaknesses, not your strength, not just going with what you got, but developing that part of your expertise that is most vulnerable, that you perform the worst at. And in my mind, that's a critical thing, okay? This would be one of my weaknesses. One of the reasons I agreed to do this. Basic truism. No such thing as a fact. There's only statements of fact. Judges are not actually looking at the facts. They're looking at what people say about the facts, what the doctor states, what the QRC states, what the employee states. A high credible source is more effective with low involvement listeners. If the listener is highly involved in the issue, they tend to have their own opinion. they tend not to listen to an expert and not to adopt that opinion as easily. Okay? Credibility is an eye of the beholder. Perception of credibility changes over time, and credibility is king. Okay? If the judge feels you're credible, if the jury feels you're credible, you got them. Okay? I don't know how that works, really. It's this thing that you want to work toward and achieve when you're able. Any questions?
Ken, more of a statement, maybe you can tag along. But, I found it interesting.
Microphone?
No, I'm good.
I'll repeat.
I found it interesting that writing is only 1%, whereas the credibility schematic, writing is only 1% of the effectiveness.
Yeah.
He's going to repeat it.
Yeah. Jeff's saying he found it interesting that writing is only 1% of a credible, or an effective speaker or witness.
Yeah. What are your thoughts, Ken?
Depends on the audience. If it's a jury, I absolutely believe it. Okay. If it's a judge, if it's a work comp judge, no, not necessarily. Now I'm assuming they read the reports. Okay. If they do, then your writing matters. How you write reflects how you think. If your writing is all over the place, well, that means your thoughts are all over the place. Okay, writing is how we express and structure our thought. It reflects how our brain functions. Okay, so that's my take on it.
Hi, Ken. Dave Hobson. Hey, a question for you. What percent for your work comp work? What percent of your work come from plaintiff attorneys versus defense? And I'm not saying that to put you on a spot, but more of a question of like, do you feel that in any way affects your credibility with one side or the other, if it does at all?
My work is 100% plaintiff referral. Okay, that's the way I like it. It's the only way I would do it. And I apologize to no one. Much to the chagrin of the defense bar, I don't yield to them anything on that issue. Okay? So yes, it affects my credibility. They think I'm a lying scumbag, and I need to prove different to the judge in a work comp context. Oddly enough, you all know many of the work comp judges are former defense counsel. But when they come to be a judge, their values seem to kind of recenter or change somewhat. Okay, so I'm sure there are times when I'm judged harshly by a judge just because of my history and the kind of caseload that I like and that I attract. That's the way it is. The people who use me know that. Okay, so I don't apologize to it. It's not supposed to be an issue. I could work for SFM. That's not an issue either. If the SFM expert or QRC will articulate their opinion and support it with a reliable, valid rationale, doesn't matter who wrote their check. Okay? And in an expert context, somebody is paying you. Okay? There's no neutrality. There's impartiality that's based on profession. Now, the attorneys, again, are sharks, and so, yeah, they do all of that. And you can't win in an argument with an attorney. They're trained. They're assassins, okay? They do that. But let me tell you, there's few things better in life than really sticking it to an attorney, okay? If you get that opportunity, do not pass, as long as you're willing to pay the price later, okay? I've done it. And I immediately duck and run, okay? And then I just hope I don't see that attorney next month or even next year. Okay? Just one comment. Never lose control in the courtroom, okay? Bring a backbone, right? Stand up for your opinion. But don't get emotional, don't get excited. The attorneys are playing their part. Their part is to antagonize you, to trick you, to misdirect you, to confuse you. Your part is to stay focused, stay on track, stand by your opinion, state it clearly, get on with the business. Okay? Anything else? All right, thank you.